There are three pillars to any estate plan: a will, a representation agreement, and a power of attorney. A power of attorney is a document that allows someone to make financial decisions on your behalf if you can't or don't want to. A representation agreement allows you to make decisions in advance about your health care at some point when you can no longer do it yourself. And a will is a document that allows you to make decisions as to what happens to your estate when you die. A will is particularly crucial because it also allows you to deal with other elements, such as guardianship of your children. The common elements of all three of these documents is that you need to carefully consider appointing people to act for you in these various capacities. Always make sure that you not only have that person appointed and that you ask them if they'll act for you, but you also have an alternative, because you cannot force someone to act for you. The crucial elements to consider in preparing a will are things such as executors. Pick someone you trust, and always make sure you have an alternate. Who are the beneficiaries going to be? Your spouse, your children, charities, friends, relatives. What happens if there's an underage child? Are you going to create a trust for that child? What happens if there's a disabled child? Are you going to create a qualified trust for that child? This is particularly important if the child is entitled to a disability pension. What happens if you've left something to someone and that person is dead when you die? Who's going to be the guardian of your children when the last of you and your spouse passes on? These are only some of the critical elements that you should consider. Always remember that every will should be designed for you specifically, because everyone's circumstances are different.